Approaching each situation, attack their defects. Now, I'm a firm believer that you could spend your whole life dealing with, status and standing, and certainly status and standing do matter, but you don't want to spend too much time on that. Too many people focus on the silver bullet of, well, if I just prove my status and I get my status declaration, then the case is closed. Rarely does it stop there, to be honest with you. You're going to have more of a comprehensive approach in dealing with most legal situations. And I don't care whether it's a credit card, a mortgage, a criminal matter, traffic. It really just doesn't matter. It pretty much, there's some fundamental things that always have to come into play, and that is jurisdiction, and trying to void that jurisdiction or void the case, and catching the criminals, the real terrorists, at their act. If they violate your rights, public servants and attorneys are exceeding their authority. It's just that simple. So we focus on defects and how you attack that. That's a far more common sense, logical way to deal with problems than to simply run around saying I'm a glow-in-the-dark sovereign. I mean, don't get me wrong. There's importance in some of that, but don't focus too much. Don't worry about the Lieber Code and what happened in 1867 and 1933 and all these things. It is what it is. We're in a contract court system, but even in that contract court system, there's remedy if you attack it from the right angle. That's why we recommend the jurisdictionary legal course, just to have some foundation on that. There's no substitute for knowledge here. If we can simply find the defects in the opponent's papers and actions, and there's almost one defect there when they're using their fraudulent color of law system on you. Remember, they're assuming that you're a government employee. That might be a defect right there. Are you? You might not be. Most people aren't. But that's what most statutes apply to, for example. That's a defect. So the court becomes void of jurisdiction and their actions become void, which means you can go make a claim against their bonds of any officials who've harmed you and profited from you, and they are profiting from you. You walk in that courtroom, it's one of the most profitable buildings in town. Just look at the bottom line. The bottom line is, if they exceed their authority, they have no authority, they're acting outside their authority, that gives you something to attack to void the case. That includes possibly even previous convictions or judgments against you. So if you can focus on defects, you can remedy a lot of situations. You don't have to try to come up with magic money and try to turn your birth certificate into a pot of gold. You simply use a little common sense, break apart their case, and discharge what they've charged. That's really where a real discharge happens. It's how you act. So let's look at some of these types of defects. Typically, there's some kind of complaint, for example, and that would be a civil or criminal case. They issue a complaint. So the first question is there an affidavit? And I've seen warrants where there's nothing. That's a big defect. That voids the whole thing if you attack it correctly. If there's a complaint, it must include an affidavit signed by someone who alleges a damage, violation of a debt, or whatever. Do you think maybe a mortgage, you'll ever see that document? I don't think so. Credit card case? No way. They'd have to prove they loaned you money, which they're prohibited from doing, believe it or not. And that is loaning depositors money. They can't do that. They have to create credits. So there is nobody damaged in that situation, technically speaking. Now, some people will say, well, you're just telling people not to pay their bills. No, I'm not. I'm just trying to find out where the real contract is, and that's the real issue here. No contract, no controversy, no court. It's that simple. So they bring something on you that's just a statute or a code violation, which is really intended for government employees only. There's no affidavit, then there's no defect. The affidavit must state who, what, when, where the crime took place, and what the crime was, the harm was, not just the code violation. So break it apart. What's the actual harm caused, not just the code. Okay? A mere statement of violation of code is in itself defective. Let's talk about assignments. Now, assignments happen a lot in credit card or mortgage cases, or even credit card or car paper cases. Anytime that mortgage paper or paper is sold. So if a debt is alleged, is the complainant or plaintiff the original party? And of course, it almost never is in a mortgage. I've seen fourth and fifth generation parties in there, and none of them can demonstrate they have the proper paperwork to call themselves the actual claimant or the plaintiff if they're suing you. See, the original bankers institution that loaned you money, well, who are they? Oh, and did they loan you money? Well, they demand to see and inspect each assignment of the debt in the chain of assignments. Don't let the case proceed until you see this chain of assignments. You want to know the party standing across from you has all the proper paperwork to prove they are the proper party in standing. And if the proper party in standing is not there, there is no standing and there is no court. Everything they're doing is void. Don't accept the fact that they just have an attorney standing there talking to you as that it's being valid. So there's a foreclosing trustee coming after you, demand to see the chain of title. And if any assignment is missing and it's not recorded on the public and somewhere, which they never are that I've seen, rarely, then you can also look, if they do show you something, examine the dates of the assignments. You'll find that sometimes they make stuff up. And was it recorded? Probably not. If not recorded and not dated, it's a defect. Remember, anytime there's a defect, you have a cause to bring a claim. Okay? And they don't have a cause to bring a claim. You would motion the court to dismiss for their lack of standing, for not even being the proper party. How simple is that? You think I can't do this? I mean, this is just, if you had this chart, you could make a simple motion, right? Do they have the original note? Now, if they bring you a copy of a note, that's a defect. Don't accept it. But people stand there and say, "Oh, they brought the note." No, they didn't. If it's a certified copy and it's not the actual original size, that's also a defect. See how easy this is? Now let's go to section 2. Court lacks jurisdiction over the subject matter. Now, this is actually a defect with the complaint or plaintiff, whether it's a person, a corporation, a bank, a debt collector, a sheriff, a cop, or whatever. Don't get caught up on the word person right here. We're just focusing on simple things. So let's talk about qualifications of that party bringing the complaint. All right. Who is suing you? Who is the real party in interest? They almost never really is. It's not easily identified in most cases. So you would do is a FOIA request to the bar association or the bank or the county clerk or the judge or regarding the judge or the officers involved. FOIA everybody. If you don't know who to FOIA, ask who you would send a FOIA to. That's the answer. I get this question a lot. I don't know. I go to them and I say, who I wanted to do a Freedom of Information Act request as far as your status of licensing and and your oath and those sorts of things. Who do I go to? And you'll find out eventually. So we demand the qualifications of everybody involved. If it's an attorney, see if they have a real license, not just a bar club membership of a so-called license. That's not a real license. Then go after their bond for lack of their oath on the record. If you find that, you need to FOIA everything, particularly as to oaths, licenses, and bonds. If you don't get it, that's a defect. And tell them you're going to publish this information, that they're operating out there in the public without their bond. They'll want to probably settle with you. That's what you're after here. If the party has no standing to sue, the complainant has no standing to sue. If it's a corporation, verify if the corporation is registered to do business in the state. That's happened a lot in debt collector cases. So find out. If they're not, that's a defect. They don't have the standing. They're not the party. I mean, you shouldn't be able to lose a lawsuit to somebody who isn't in the right party, right? And you have the right to ask for these things. Don't just assume they're right because they say there's a debt. That would be foolish. So he walks up to you on the street and says, "Pay me money because you owe it to me." You're going to say, "Who are you?" Well, that's all we're saying here. And check their other qualifications. There's 12 U.S.C. 72 and 73 for that entity. Just go look it up and see what that means. If a bank, do they have a main office or a branch in the state? If not, that's a defect. Guys, you think they won't? Do you think they wouldn't try this stuff? But they do it all the time. Item 3, court lacks in personam jurisdiction. The court must have personam jurisdiction, that is over the person, over you, right? Trickery is often used to get you to acknowledge the name on the action. They'll say, is this your name? Or do you understand? And when they're talking about you, you'd have to say, well, who's you? Because who are we really talking to? Are they talking to an entity or an estate which they want to tap into? That's what they want, actually, not you. They want you to be the guarantor or the surety of it. And then when you answer to the name, you also agree to be the trustee, and trustees are the liable parties in a matter. So, you're there only due to the fact that I can't participate in this matter at this time because I have to know who issued the summons using threat, duress, and coercion. Threat, duress, and coercion voids any presumed contracts, and therefore the case lacks jurisdiction. You can't be forced into a contract. There is no jurisdiction if there's no contract between the parties. There's no jointer. And they almost always use threat, duress, and coercion, don't they? Don't you feel threat, duress, and coercion when you fill out a form sometimes, or a tax form, or a driver's license application? That if you don't do it, something's going to happen to you? Yeah. You see, we're doing this to ourselves all the time. Item 4, court lacks subject matter jurisdiction. Can this particular court hear this type of case? Now, this is typically done correctly. I mean, if it's a tax case, you might go to tax court. If it's a traffic case, you might go to traffic court, and so on. But sometimes you can find out that there's a defect there as well. 5, procedural errors. The laws govern and dictate how long certain actions have to be performed. So you'll find that quite often in the legal system, people take shortcuts. Lawyers take it all the time. Cops take them all the time. So look for date timestamps on papers. Check everything. I've seen many cases won just because somebody put the wrong date or time in, and because they basically made up the document later. Well, that's sorry. You can't be stealing from people and making up paperwork just to make money from them. I don't care whether you speeded or you were speeding or not. That's not even relevant if they're violating your rights doing it. Okay? So you look for a defect there in the procedural error. So you got to go look up, did they follow procedures correctly? And you'll find they didn't. And if they don't, there's a whole section of IRS manuals on the procedures that they have to comply with, and they don't do it all the time. It has to do with taxpayer bill of rights and things like that. Don't be afraid to use that. Some people get so caught up in the sovereign thing, they forget that, what if I just catch them on a procedural error? I don't have to try to prove all that other crazy stuff. I just want to find out if they didn't follow their procedure and moved for their action to be dismissed. That's all you're doing. If there's a flaw in a warrant. Now, warrants must have a wet ink signature, not rubber stamped. You want to see the original. And an attached affidavit. And, this is the third part that's quite often missed, a complaint by a real damaged party. This is the part where it gets a little tricky because if it's a traffic ticket or something else, there's no real damaged party making the complaint. An investigator might give an affidavit like a cop, but the reality is, did he sign it under penalty of perjury? And is there a complaint of a damaged party? It's usually missing that third thing. So a living man versus you, is there a living man versus you, a living man or woman? Or is it some state fictional entity? And they're not even coming after you, they're coming after your estate name, which is the all capital letters typically, not always all capitalized, but that's what they're after. That's the thing that was used to create that license or whatever, is that birth certificate estate. They're trying to tap into that thing. And they want you to not know what's going on and let them have access to the credit that's in it. So warrant defects might include a missing wet ink signature by the official judge or governor. No warrant is maybe sometimes a warrant is prepared after the arrest, or there's a warrant missing an affidavit and a complaint. If it doesn't have those two things, it's just a piece of paper. This is really sometimes called an information. Now, other affidavit defects might include if it's missing the affidavit, or there's no sworn or notarized witness. Swearing under penalty of perjury. So look at all these things. Is there a witness, and are they swearing under penalty of perjury? Then it's just a writing. Is there a signature? Is there a real wet ink signature that somebody else write on it and give you a copy of it? I want to see the original. That's the real contract. Then if there may be content or statements that are defective. If it fails to state who, what, when, where, this particular crime occurred, rather than just a speculation that there might be something generally going on, well, that's a defect. Some affidavits only claim the defendant generally presumed to have violated some law or code without any specifics. Okay? It's got to be specific. It's like you killed this person at this date and time at this location. Outside of that, the rest is just a bunch of codes and general statements. And it's not valid. But it'll go over in the court all day long. The judge will allow it all day long until you object and bring up the issues and start making them prove things. Remember, we say that your job is to ask questions and make them prove their claims. Okay? That's all you need to focus on. And they're based upon these issues. Just ask the questions. That's how you do this. Flaws in the personnel involved. The jailer, deputy, sheriff, cop, bailiff, judge, agent, prosecutor, whatever. They must be qualified to hold their office, so don't allow anything they bring in, any document they've touched or anything, go past without a FOIA for their qualifications. That includes their bond, oath of office, and other things required by the law in that office. See, these people, even if they work for a corporation, let's just forget about the fact that the whole government is a corporation. It is. But even then, in their contract with that corporation, they must uphold their oath of office and bond. They take that anyway. So, people get upset that the government's become a corporation. Okay, so it is. It is what it is right now. But they still have a protective clause that they have to abide by. So you have the right to hold them accountable to that. You still have your constitutional protections. Okay? If they don't have the constitutional authorization over a man or a woman, then they never have it. They may only have it over estates or entities with names, right? That's the estate. But they don't have it over you. Or they may have it only over government employees. That's a big problem. So is there oath of office on the bond? No oath. That's a defect. The office is vacant, which means they're acting outside their protection. And they have no standing. Everything they say and do is now taken out of the case. And if the case started with what they did, guess what? Everything after that, fruit of the poisonous tree, is also poisoned and not admissible as evidence. Should be a case dismissed if you motion for it. Don't stand there waiting for them to do it. You got to move the court. Are the bonds on record? Then the office is vacant. That means they are not acting with the proper authority. Other qualifications to hold office. Do they have all of them? If they're missing qualifications, if they didn't fire the gun within 6 months of the original certification date, and that's what the qualification requires, then the office is vacant. They have no standing to take actions. Okay? Now, you've got to push the judge on this stuff. You got to hold them accountable as well. Don't just wait for them to do it for you. That's the big mistake most people make. So attorneys don't have any licenses. They just have union bar card memberships. So it's not even authorized by Congress. Ask them. Show me the act by Congress that gave you a license. Why I can't also talk about the law and support my fellow man. Where's the act by Congress? It doesn't exist. In other words, there's no law. So all attorneys technically are in fraud in their cases when and the cases they're bringing are void. I've seen one guy that he's pretty good at this. He beats the attorneys up more than the banks in a foreclosure case because most all of them are acting outside their authority. And it's kind of hard to move their case forward if they can't bring an attorney in. Okay? So you got to look at the pieces of the puzzle and find the defect. Denial of due process rights. Now, this is done a lot. Court officers or actors taking actions without proper warrant, proper standing, proper holding of office, or steamrolling over you regardless of properly established jurisdiction in all areas where jurisdiction has been contested. You must object to those actions. Okay? For failure to prove on the record that the court has jurisdiction. If you don't do it, though, they will move forward because your silence is your agreement. Your silence, not asking these questions, not bringing these points up, is your consent. That's just the rule of law. Somebody accuses you of something, you don't deny it, and you don't make them prove it, then it's probably good enough. And that's how the rules of the game are played. Like the rules or not, those are the game. Those are the rules. So this chart right here can help you start to take apart any case against you. Examples, other things where they deny your due process. They force you to take fingerprints, photos, or DNA examples, and you tell them we don't have a contract, and I'm not waiving my rights voluntarily. Okay, that's what you want to do. So after you've sort of looked at one of these chart issues, then you need to go through sort of this general process. The key is to point out defects on the record and do it on the record so everybody sees it. Ask for discovery. Motion to compel the discovery. Get it in the record. Once they start seeing the stuff appearing in the record, they tend to want to go away. So keep pushing for dismissal at every step. A motion to dismiss because they failed to provide a proper warrant. Motion to dismiss. They were out of office for. You see what I'm saying? You just keep hitting it, keep moving things. So start your discovery early when something's going on. Start with your FOIAs on the attorneys, the cops, the agents, CEO, anyone in the public servant involved. Find out who you have to FOIA to get their bonds and oaths and things like that. Don't know? Ask around. Don't ask me. I don't know. Every might be different in every state, but generally speaking, there are bosses. There are places where these records are held. Ask around. You have a right as one of the people to ask these questions. So stop asking, being cowardly, and tell them, hey, I'm here to get this information. I need to know this for my case. Who do I talk to? Who has that information? Okay? Don't let anybody push you around. You have a right to this. They aren't your masters. They are your servants. Then do an abatement process. So if there's something going on, get your affidavit of status out, get your, notifying that you're not the fictional entity, what your relationship to that entity is actually, and how you're acting going forward, and get it back to the court and let them know. And that's what an abatement does. It lets them know your status, tells them who you are and what it tells them there's no contract and all those sorts of things. Now they have to disprove that issue, which they won't be able to do. 3, a writ of mandamus. That's just a way to enforce the FOIAs if they won't give them to you. It's a separate document. 4, issue a public notice and let them know you're about to issue a public notice of your findings of their status. Boy, I'll tell you what, an attorney or a cop or an agent doesn't want their name published in the public. Basically what you're doing is doing a public notice saying, I've done a FOIA, I found no other evidence to the contrary, I believe this person's acting outside their authority, and this is just my public notice of my findings. That's all you're doing. But don't publish it, obviously, unless it's true. That could get you in worse trouble. So be sure that you only publish the facts. And let them know right before you do it. Always give your brother an opportunity to remedy the problem. Okay? It's not about revenge. If you ever do things out of revenge, it's going to come back and bite you. Do it out of authority and give people an opportunity to remedy the problem first. Then you can use criminal complaints for using sham legal process, lack of jurisdiction, for their defects, whether it's a collection, mortgage, tax, traffic issue, it doesn't matter. Okay, unless it's really a personal issue, like if there's a marriage and a divorce, that's tough because you're into a contract there. You got to break that contract. That's what you're doing. But on these kinds of issues, it generally doesn't matter. They want to negotiate without going to court. That's really what you're trying to do here. You think, I can never go to court and be Perry Mason. Well, if you do it right, you won't have to. Your discovery and your notices will do a lot to make them want to negotiate with you. You don't want to do this for a court. And the key is to never go to court. And if you do all these other things, and you let them know you're doing it, and you let them know you're about to publish it, and you let them know you're doing a criminal complaint, believe me, they're not going to want to go to court. And that's your goal. And then if you have to, let's say it comes down to really, you've got to do something, then you got to know how to file a suit. That's where that self-help legal course comes in handy. You make your claim. You go on offense because they violated this, and now you're suing them administratively. Remember the O.J. trial? They tried to get him on the murder thing. They couldn't quite. They created just enough reasonable doubt. They found just enough defects in the case that essentially he got off. But then he didn't really get off because they came right back in with a new suit and a claim which has a lower standard of proof. And there was definitely damages caused, and they won that case and basically took his entire estate. They probably gave him administrative remedies, letting him know we were coming, and he couldn't answer. Became pretty much an open and shut case to win that suit. So that's an example of how you do all this, okay? And we don't want to deal with situations where somebody really is harmed and that person caused the harm. we don't participate in that. But if it's dealing with these contractual things where they're just coming to steal money from you, you need to know what the truth is, and you will need to ask for the truth, and you need to hold them to the truth. This isn't about being denying paying something. It's about asking questions and getting real answers, getting to the truth. If you come to find out you owe the debt, you pay it. You negotiate it. Work it out. Sometimes it's better just to work out a traffic ticket than to fight it, okay? Because it's small enough that you need to go fry bigger fish. Don't go try to prove something. But, if these things are something worth fighting for, don't focus on just being angry or being a sovereign. Focus on attacking their defects. That's a far more productive way to go about protecting your rights. And that is, to me, what a patriot or sovereign is somebody who knows how to ask questions that are intelligent, that are reasoned, that are based upon their own rules and procedures that they violate all the time, and you catch them at it. That's it. Hold your public servants accountable. And that's really, to me, how you handle most legal situations in a general sense. So want to learn more, go to UR Law and become a premium member. We start off as a free member, but then you can upgrade to a premium member if you want to learn more than just the basics and you want to get access to some of these documents and tools. Until then, see you next time.